A standard first DUI is usually a misdemeanor. But Vehicle Code 23153, California's DUI causing injury statute, changes the equation the moment someone other than the driver is hurt. The prosecution must show two things: that you drove under the influence, and that an unlawful act or negligence caused injury to another person. That second element, causation, is what separates a misdemeanor DUI from a felony charge. Prosecutors can sometimes file VC 23153 as a misdemeanor when injuries are minor, but serious harm almost always means a felony filing. The difference in consequences is significant. A misdemeanor conviction may mean county jail, but a felony conviction can mean state prison, a strike under California's 3 strikes law, and a much longer license suspension. The charging decision rests entirely with the prosecutor. California law adds extra prison time for each additional person injured in the crash. Under VC 23558, prosecutors can tack on up to 1 additional year in prison per injured victim beyond the first, up to 3 years total in enhancements. If a victim suffers great bodily injury, meaning serious, significant physical harm, Penal Code 12022.7 can add 3 to 6 more years. These enhancements stack on top of the base sentence. If you have a prior DUI conviction within 10 years, a felony DUI causing injury carries mandatory minimum jail or prison time and longer license consequences. A third or subsequent DUI causing injury is almost always charged as a felony regardless of injury severity. Prior convictions are tracked by the DMV and by prosecutors, and they drive both the charge level and the sentencing range the judge considers. A felony DUI causing injury triggers an immediate action by the DMV separate from the criminal court. Your public driving record, the one employers and insurance companies can pull, reflects the conviction for 10 years. But the DMV keeps an internal record permanently, and that internal record is what counts as a prior if you are ever arrested again. Results vary case by case, but the DMV and criminal consequences run on parallel tracks. After a felony DUI causing injury arrest, 2 processes start at once. You have 10 days from the arrest to request a DMV hearing, or your license will be suspended automatically. On the criminal side, you will be arraigned, and the prosecution will decide how to file. Evidence like blood alcohol results, accident reconstruction, and witness statements all become central. The specifics of your case, the facts, the injuries, the circumstances, shape everything that follows. Understanding what VC 23153 actually means for your situation is the first step. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.